This conference will now be recorded.
All right, so welcome again, everybody. Again, it's Mary with the Lupus Society of Illinois. Thank you for joining. Before we really get going, I wanted to just remind everyone that this event is for educational and informational purposes only and serves to benefit our mission. The Lupus Society of Illinois does not provide medical advice or recommendations. This information should not substitute or replace expert medical care. Before making changes to your medical care, consult your qualified healthcare professionals familiar with your medical condition and health status. This event is being recorded and will be archived on the Lupus Society of Illinois' website. I also want to let you know that I'm going to ask that you keep your phones or your microphones muted, and I'll kind of be checking that out. There will be time for questions at the end, or if we do run out of time and your question hasn't been answered, you can always contact me, Mary at lupusil.org, or call the office, and Jeff is always wonderful about following up and answering our questions. So that is a little bit of business. Now, without any further ado, I want to introduce Jeffrey Rabin. As I've mentioned, he's been a great supporter of the lupus community for many years. He's been a presenter and an advocate for us. He's been representing individuals with disabilities and medical legal issues since 1980, and he began his law firm in 1988 to focus his practice in the representation of disabled persons seeking Social Security disability benefits. And without any further ado, I'm going to pass the presenter over to Jeff, and we are going to get started. Oh, there you go.
All right.
Jeff, we got you now. We can hear you now.
Okay, and let me get my screen up. Mary, stay with me just long enough to make sure that you can see my PowerPoint from beginning. There, is that showing up?
All the way down to July 16th, 2020. We got the whole thing.
Perfect.
Wonderful, thank you.
Okay, thank you, Mary. So good evening, everybody. My name is Jeff Rabin. I'm an attorney, and all I do in my law practice is help people who are disabled and are trying to get benefits from the Social Security Administration. I became an attorney in 1980 and started out in a small general practice law firm downtown in Chicago, where I got stuck with the Social Security cases. And that's because nobody else in that law firm wanted to deal with these clients or this bureaucracy. As time went on, I found I liked the clients and I liked the bureaucracy a whole lot more than I like other lawyers. And the nice thing about my work is I don't have to deal with other lawyers. It's me, the judge, the client, and off we go. I did my first disability case in 1981. I set up my own law firm in 1988 just to do disability cases. We represent people around the country. We give groups talks to groups like this all over the country. I have testified before Congress on these issues. I've been on 60 Minutes. I've done lots and lots of work with the Lupus Society of Illinois and very proud of that relationship. So this is our thing. So here's what we're going to do this evening. We are going to talk about what it means to be totally disabled. What does that actually mean under the law? We're going to talk about what SSDI is and what SSI is and what the differences are, because those differences are really important in terms of your planning and understanding these programs. We're going to talk briefly about how Social Security thinks about cases, because they do think about every case. They just usually do it wrong. But we'll walk you through their analysis. We're going to talk about the keys to getting a claim approved. We're going to talk about the application and appeal process. And if we have time this evening, we're going to talk about the most important part of the program, which is how to get off. And that's to get better, get stronger, and return to work. There are really good return to work rules built into the Social Security Act, but they're scary and confusing. We have them outlined in our handout here today. And if I have time, we'll get to that. Normally, this whole talk takes about 90 minutes, and we only have 60 tonight. So I will stick around for questions as long as Mary can keep the link up. And I will also have the PowerPoint available. You can either contact Mary at the Lupus Society, or you can email me and I'll be happy to send it out to you. Now, before we get into substantive stuff, let's talk about the impact of COVID-19. Social Security is still working, but their offices are closed. In the very beginning, this was a nightmare. Even though Social Security historically had a great deal of their people teleworking, that had actually been cut off by the new commissioner who wanted to end that benefit for Social Security staff. So a lot of the telework services had been terminated, and then lo and behold, 2 months later, everything ends up being closed. So the staff is working, all the bugs were worked out, but obviously nothing is being quite as efficient, if you could ever use that term with Social Security, as it was in the past, and things are moving slower. Checks are still being processed, people are still getting their benefits. Administrative law judge hearings are supposed to be face-to-face. That's what the law says, that's the purpose of them, that's why we try to always be ready to do hearings with judges, but that can't happen now, so now they're happening by telephone. Sometimes telephone hearings are okay and they're appropriate, sometimes they're not. Law firms and representatives are all over the place, but it's been pretty clear that Social Security is in no hurry to reopen their office, so almost everybody is doing some telephone hearings where we really feel it's inappropriate. We do have the right to ask the judge to hold the case until face-to-face hearings are resumed, but who knows when that will happen? There's no idea right now. We have gotten a lot of calls from people who said, I tested positive for the coronavirus and I want to get disability. The answer is the same as in any other situation. So what? You know, it's not a totally disabling condition unless you have symptoms that are going to impact your function over a very long, at least 12 months period of time. So for the vast, vast bulk of people, testing positive for this disease is a non-factor for disability issues. So that's where we're at. Even as of today, the material that I get in blogs and newsletters indicates there's no plan at Social Security that would indicate to us when the offices are going to reopen or when face-to-face hearings are going to start. All right, let's get into our substance. In order for me to get somebody Social Security disability insurance or supplemental security income benefits, we have to meet the same test. And that test requires that we prove that people are totally disabled. Totally disabled means that I have to prove the existence of permanent physical or mental impairment, producing some sort of severe preclusive ability for substantial gainful activity for a period that's less or expected to last at least 12 months or result in death. And I always say it like that because I don't want you to write that down. That's a lot of legal mumble jumble. So let's talk about what it really means. In order for me to get somebody benefits, I have to prove that you are suffering from a medical problem that produces symptoms which so impact your day-to-day function that for a period that's lasted or expected to last at least 12 months, you're unable to perform even basic work activities at a simple, unskilled, low-stress job. I said that very carefully. I did not say I have to prove you have lupus or have to prove you have a medical problem. This program is not focused on diagnosis. Benefits are awarded for people who can prove that their symptoms from that diagnosis are so severe and so chronic that the symptoms make it impossible for them to perform any type of full-time work activity available in the national economy. I get calls all day from people who say, Mr. Rabin, I have high blood pressure and sugar diabetes and I want to get SSI. And my response is always the same. So what? Take your medicine, watch your diet, get a little exercise, and go get a job. Not to deny that there are very severe problems. My father passed away from untreated hypertension, and many people with diabetes suffer very severely. But the typical person, especially the adult type 2 diabetes, they do not have those types of symptoms that would make them totally disabled from the ability to function at a simple sit-down, no lifting job. So it's not a question of whether you have a medical problem. The question is, what are the symptoms from that medical problem? and how do those symptoms impact your day-to-day life? So when somebody calls me and they have a physical medical problem, a bad heart, a breathing problem, a bad back, lupus, fibromyalgia, my questions are always the same. What are the symptoms of that physical medical problem? And how do those symptoms impact your ability to do the basic physical motions of a job? Sitting in a chair, standing, walking, lifting, reaching, pushing, pulling. Those physical motions that are involved in every job, how are they impacted by the symptoms from whatever that physical medical problem is? If you have a mental impairment, major depression disorder, anxiety disorder, PTSD, agoraphobia, the most common call we get is bipolar disorder. What are the symptoms of that mental impairment, and how do those symptoms impact your ability to do the basic mental motions of a job? Understanding and remembering simple 1 or 2 step instructions, interacting appropriately with supervisors, coworkers, and the public, dealing with work stress and work changes. Those basic mental motions that are involved in every single job, how are they impacted by the symptoms from whatever label the psychiatrist put on you? You see, Social Security rarely disagrees with the diagnosis. That's usually never a problem. A guy's got a scar 6 inches down the middle of his back. He had a back fusion. Social Security's not going to deny that. What they're going to say is, so what? He's had his back fusion. What are his symptoms? And how do those symptoms impact his ability to function in a work setting? And they call that in their lingo your residual functional capacity to perform work-related activities, RFC, what you can still do despite your medical problems on a full-time basis. We're going to come back to that term RFC a couple of times this evening. And then Social Security takes this RFC that they develop for every single person that applies, and they apply it to the mythical world of work. And this is something that people often have a hard time understanding. This is not a jobs program. This is not a we feel sorry for you program. It does not matter whether you would like the jobs they could identify, or whether they pay a living wage, or whether the job openings exist, or whether you could travel to those jobs. None of that is going to be considered, especially for people under 50. At 50, if you've only done unskilled work and don't have a GED, it's considered a little bit. At 55, a little more. But these real world problems generally are not factors in a disability case. The only thing that Social Security is looking at in a disability case is what are the symptoms and how do they affect your ability to function. So let's take an example. Let's take a 49-year-old Chicago union carpenter. He's making $43 an hour scale plus benefits. He's climbing a scaffold tips, falls, he lands on his back, he fractures a vertebrae, he herniates 2 lumbar discs, and he has a back fusion. He is never going to be a $43 an hour carpenter again. But that's not the test. Social Security is a total disability program. So I have to be able to prove that this man cannot function full-time as a ticket taker at a movie theater. Sit-stand option job, there's no lifting, you just rip the tickets in half, and you say door number 2, enjoy the show. Ticket taker at a movie theater, coin changer at a self-service gas station, shoebox packer in a shoe store, washing machine unloader in a laundromat. These are the kinds of jobs that Social Security has used to deny my clients benefits in the past. A number of years ago, I was representing a lady in downtown Chicago who was a cardiac intensive care nurse, and she was zapping people like you see on TV and saving lives. She developed rheumatoid arthritis and ended up with 2 claw hands as a result of the disease. Social Security denied her application, saying that she retained the RFC, residual functional capacity, to be a bicycle rental clerk. Now, she was never going to get that job and never going to do that job, but that's not the test. The test was whether I could prove she could not function at that job. If I did, I won. If not, I lost. So if you want to write down one word on whatever paper or notes or computer sheet you have in front of you that will summarize everything that we've talked about so far, you want to write down the word do, D-O. Social Security disability claims are not based upon whether or not you have a medical problem or diagnosis. They're based on what you can do on a full-time basis despite the symptoms from that diagnosis. If I can prove you cannot do any type of full-time work, I win. If they can prove that you can still function at some of those somewhat ridiculous jobs I discussed earlier, we lose. And that's the basis for every single Social Security disability insurance and supplemental security income application. Now, this basic law, proving the inability to function at any type of full-time work activity, applies to two different programs. The first one is called Title II of the Social Security Act, or Social Security Disability Insurance, SSDI, Workers' Disability, Regular Disability. We'll call it SSDI tonight. The second program is called Title 16 of the Social Security Act, or Supplemental Security Income, or SSI. We'll call it SSI. So we have SSDI, SSI. Let's first talk about SSDI because it's the more comprehensive of the programs. SSDI has two requirements. First is the medical test, which we just discussed. Second, you must have bought the insurance. Social Security Disability Insurance. This is an insurance plan, and it's purchased just like your auto insurance or just like your homeowner's insurance or just like your health insurance. And you purchase it by working and getting a check. Now, if you're like my staff, all of you that have worked made a deal with the boss. And according to my staff, the deal they made with the boss is for not enough money, they work too many hours and under too much stress. But that's okay. That's just the boss-employee relationship. The problem is not one of you has ever gotten a paycheck for what the boss promised. Why? Because every time you've gotten that check, it's had a stub, and the stub has lines on it. Now, the top line on that check stub says federal withholding. That's the money that goes off to Washington, D.C., and it pays for the Army and the Navy and the Air Force and the Smithsonian Institute and all the other things that are going on at the federal government, including our stimulus checks. You've got the bottom line on your check stub. That says state withholding. That's the money that goes down here in Illinois to Springfield, and truly only the Lord knows what happens to it down there. But we know that some of it goes for roads and bridges, some of it goes for hospital assistance, not enough of it goes to Medicaid and public education, which are two other interests of mine. And then you've got the lines in the middle for the money that goes over the rainbow to the land of FICAville, FICA. Now, I don't know actually with this program if you all can see me or not, if you're all just seeing the PowerPoint, but you could see me on my website or whatever, and you'll see that I have a fair amount of gray in this beard now. So I do remember when our check said FICA, but they don't say that anymore. It's now divided into two lines. One says Medicare, and the other says, oh my gosh, I'm mental blocking it. Old Age Survivors and Disability, OASDI. And combined, those two are your FICA payments. And they're matched by the boss. Every dollar taken out of your paycheck, the boss reaches into her purse and she matches it dollar for dollar. And your FICA payments and her FICA payments go off to Washington, D.C., and they're put into the trust funds. And this is important to understand. None of us have money at Social Security. None of us are drawing down an account. None of us have money being invested. None of us have mutual funds at Social Security. We have interests in three trust funds. The big one that eats up most of the money is called Social Security Retirement. There's a little one, and little is in the billions, so this is all relative. off to the side, and that's called Social Security Disability Insurance. And there's another little one off to the other side, and that's called Medicare. And that's how these programs are funded. We work, we pay our FICA taxes up into the trust funds, and then that money is immediately sent out. So those of you who are getting SSDI or who have parents who are getting retirement benefits, or know people whose spouse died and they're getting survivor's benefits, they're actually getting the dollars that workers sent in last month. Whatever is left over at the end of the month in the trust funds that is not paid out to current beneficiaries is loaned to the US Treasury so that they could lie to us about the size of the federal debt, because if they ever factored in the debt plus what they owe the trust funds, nobody would have any faith in the US economy anymore. In order to qualify for SSDI, you have to meet a two-part FICA test. First, you had to have worked and paid FICA taxes for at least 40 quarters in your lifetime. Second, you must have worked and paid FICA taxes for at least 20 quarters of the 40 preceding the onset of disability. An easier way, 5 of the 10 years prior to the date that you became totally disabled. Let's take an example. My life is pretty much an open book. I'm a pretty open guy, and you learn a lot about me in these talks. One of the things about me is that I'm a klutz. And I leave the house later this evening because my wife wants me to go to the store. That meant I had to put on shoes with ties, my gym shoes. I walk out of the house, I trip on my shoelace, I fall and bang my head. She gets concerned. She takes me over to Highland Park Hospital. They do an MRI and they say, oh my God, Jeff has more brain damage than he was when he started the lupus talk. Now I'm totally disabled. I go to Waukegan, Illinois, where my Social Security office is, or I call them now since I can't go there. And the first thing they're going to do is pull my earnings record off the computer and say, has Jeff worked and paid FICA taxes at least 40 quarters? I've actually worked now and paid FICA taxes more than 40 years, so I'm way past that. Then they pull my earnings record from 2009 to 2019, the 10 years prior to the year I became totally disabled, and ask, has Jeff worked and paid FICA taxes at least 20 quarters of that time period? If I've only worked and paid FICA taxes for 18 quarters of those 10 years, or for 3 years, or I worked for cash and never paid the man a dime, I'll have screwed myself because I wouldn't have purchased the insurance. Working for cash is a very bad idea if you're not paying your FICA taxes. If I'm totally disabled and I worked and paid FICA taxes, then I'll be eligible for a monthly check. The amount of that check is a computer formula based upon my age and the amount that I paid into the system. The average person on disability is supporting her family on about $1,250 a month. Nobody gets rich or comfortable on SSDI, no matter what the Wall Street Journal and Reader's Digest and certain factions of Congress think. Dependents get benefits. That's kids under 16 or up to 18 if they're still full-time in high school. You get a cost of living adjustment each year based upon the inflation rate, which never really matches what our increases are for gas and food and housing and the things that, and energy, the things that impact the disabled the most. And you become eligible for Medicare 29 months from the date you became totally disabled. Let's take another example. I become totally disabled today. This is July 2020. In the SSDI program, there's a 5-month, what they call elimination period. We call it a starvation period. So I would not get a check for August, September, November, December, January. My first check will be February of 2021. Medicare will kick in February of 2023. 2 years, 5 months from the date I became totally disabled, or 29 months. 2 exceptions to that rule. That is for people who are on kidney dialysis, and another exception is for people with ALS. No real legitimate reasons for those exceptions other than a good lobbyist or somebody interested in Congress to help those people. That should be eliminated for people with lupus and for all other conditions where they need Medicare. There shouldn't be this long waiting period. That's just a function of all of you getting involved with groups like the Lupus Society of Illinois and advocating on your behalf more strongly. I cannot overemphasize the importance of every one of you participating with the Lupus Society or other agencies that work on behalf of people with chronic medical illnesses to protect the Affordable Care Act, to protect expanded Medicaid, to protect access to the health insurance system for people with pre-existing conditions, and to expand eligibility for Medicare, Medicare Advantage, and Medicare supplement plans so that people can get important health care. It's critical that every one of you stand up in this battle because there are plenty of people and well-funded people trying to take these benefits away from you. Okay, so that's SSDI. Worked, paid FICA taxes, became totally disabled. Let's talk about SSI. SSI also has two requirements. One, that you be totally disabled, and the second, that you be indigent. So this one is means tested. Assets and income make a difference. To be indigent under this law means that you have no money coming into the household other than possibly TANF for child support benefits, and less than $2,000 in non-excludable resources. What do we mean by non-excludable resources? You're allowed a house if you're living in it. You're allowed a car because you have to go to the doctor. But they will look for bank accounts, savings accounts, checks accounts, 401ks, 203bs, cash value life insurance, poorly drafted family trusts, investment properties, vacation homes, any asset that can be converted to cash, even if it takes a tax and a penalty to access it, counts against the $2,000 limitation. So this is a program for people who are permanently and totally disabled with very limited financial resources. If you meet that requirement, you're eligible for SSI. If you're living independently, and that is you have a rent requirement, the maximum benefit is $783 a month, plus Medicaid and food stamps. Realize that this leaves a totally disabled individual 25% below the poverty level in the United States. Again, contrary to what the Wall Street Journal, Reader's Digest, and certain factions of the government think, nobody gets wealthy, nobody gets comfortable, nobody has easy life trying to live on SSI. Excuse me while I take a quick drink. A big problem with the SSI program is a concept called deeming. Deeming says, what belongs to me belongs to my wife, Sherry. What belongs to Sherry belongs to me. What belongs to the two of us belongs to our minor children, which they're all grown now, but if we had any. Now, I normally have a very long story to explain how bad this concept is, but I'm going to short circuit it so that I have time to deal with the other things we want to talk about tonight. But the way deeming works is stay-at-home parents get screwed. So the most common is the stay-at-home mom, although we have had plenty of stay-at-home dads contact us. But where one parent stays home and raises the kids, and 10, 15, 20 years later, they're in their mid or late 40s and they're hit by a car, or they get breast cancer, or they're diagnosed with lupus or multiple sclerosis, and they're not covered by their spouse's health insurance because the spouse didn't keep it, even though the Affordable Care Act required it. We no longer have penalties if you don't have it, so a lot of people aren't covering their spouses and family members. She comes to me to get SSDI and Medicare. I have to tell her I can't get her SSDI and Medicare because she hasn't worked 5 out of the last 10 years at jobs where she's paid FICA taxes. Then she says, well, at least get her SSI and Medicaid, and I can't get her SSI and Medicaid because her spouse's assets and income are deemed to her. This happens all the time. In my one little law practice, I've probably averaged at least one call, internet chat, email, discussion a week for 38 years where I've had to tell somebody they can't get benefits because they were a stay-at-home parent. for a society that puts so much emphasis on the importance of family values and family traditions, the fact that we don't recognize parenting as work and as something that should be covered under this program, to me is obscene, but it's not likely something that's going to change in the future. So that's SSI, totally disabled and indigent. Those are the two main programs. There are subsets under these programs for things like a disabled adult child and widows and widowers benefits. We can answer those questions down the road if we have some time. But for right now, I want to move forward with the main presentation. So let's go to the analysis. So what we've talked about so far is the main law, the black letter law. But this is fleshed out in something called the regulations. And the regulations are like the fine print where everything gets explained. And these regulations are then reanalyzed by something called the rulings. The rulings are then reanalyzed by something called the palms and the hallux. All of that is reinterpreted by federal court decisions. So even though this is a little area of what they consider a little area of law, or we have what they call a boutique practice, there's really a lot of law built into this. In the regulations, they have something called the sequential evaluation procedure. And this is an analytical framework that is used by every single decision maker. Every decision maker, adjudicators, judges, appeals counsel, federal court, everybody uses this same analytical framework. But I told you you're going to learn a lot about me tonight. And another thing about me is I'm a roofer's kid. My daddy was a roofer, my grandpa was a roofer, and the only reason I'm not a roofer is I was so bad at it, they threw me out of the family business. So I don't usually talk like a lawyer talks, and I can only say sequential evaluation procedure twice in a day before my tongue goes on strike. So as opposed to that, I talk about climbing the ladder, because that's how I grew up, with the ladders banging in the back of my dad's Bonneville and the smell of hot tar, which to me is still the greatest smell in the whole world. Let's climb this ladder. First step, before you even get on the ladder, is this a compassionate allowance case? Compassionate allowance came into being about 8-10 years ago with Commissioner Astrew, who said, you know what? There are some cases we just pay all the time. And if we pay them all the time, why are we putting people through this nonsense of apply and deny and appeal? Let's just give them the benefits. They started out with about 50 conditions. There's now a little over 200 conditions that fall into this. Most of them are things you've never ever heard of. They're conditions with about 20 letters in their name. They're mostly conditions that are going to result in really obvious permanent impairments or death. Brain cancer is a compassionate allowance. Alzheimer's, Huntington's disease, liver cancer, these are compassionate allowance cases. Lupus doesn't fall into this condition, so this will not be a compassionate allowance case. So we go to step 1 on the ladder, which asks, is this person involved in substantial gainful activity? Make it easier. Is this person working? Make it easier. And now this you can write down. Are you performing work where you're earning at least $1,260 gross in a month? That's the definition of work for the purpose of getting benefits. It's defined differently in different parts of the program. But for getting your application approved, the first question is, are you making gross wages in a month of $1,260? If you are, you're not likely to be approved. You're going to be denied at step 1. The only way around that, if we can prove it's like sympathetic employment or it's your Uncle Herbie that is employing you and you're really sitting in the back of the warehouse and smoking cigarettes and not really doing anything. Assuming you're not working, we go to step 2 on the ladder, which asks, does the evidence indicate that this is a severe impairment? And severe for this purpose means a condition that produces symptoms that impact on function. So the best way to describe this is give examples of what's non-severe. Hypertension, serious medical problem, but it doesn't produce symptoms that impact on function in a work setting. Sinusitis is one that's often a non-severe impairment. The best example of what's a non-severe impairment is a seizure disorder controlled by medications. Now wait, a seizure disorder, that's really a serious medical problem, and it is. But remember back in the beginning, we said that it isn't about the diagnosis, it's about the symptoms. And I described this as a seizure disorder controlled by medication, so you're not having seizures. If you're not having seizures, you're not having symptoms. If you're not having symptoms, there's no impact on your work function. Yeah, maybe you shouldn't be a bus driver or an iron worker, but much short of that, if you're not having any seizures, that seizure diagnosis isn't producing symptoms that impact function. It's a non-severe impairment. Let's presume that you have a condition that does impact on function, fatigue or pain or limited motion or use of arms or limbs or concentration. We go to step 3 on the ladder. Step 3 on the ladder asks, does the evidence indicate that this condition meets or equals the listings of impairments? Now, the listings of impairments are also in the regulations, and they're page after page after page of very, very specific medical criteria for lots of different types of medical problems. There's listings for musculoskeletal problems, there's listings for cardiac problems, there's listings for hematological problems, there's listing for mental disorders, and there is a listing for systemic conditions, including lupus, and we're going to talk about that in a moment. Listings are very hard to meet. Cut my arm off, I don't meet the listing. Cut my arm and my leg off, I'm a double amputee, and I do. We've had over 50 clients in our office die, and Social Security said they didn't meet the listings yet. But this is always the first place that my intake team and myself will think about when new clients call, because this tells us what Social Security is looking for in terms of symptoms and severity. So the listings are very important. Let's assume you're not working. You have a condition that impacts on your function, but it's not so bad it meets or equals the listings. We go to step 4 on the ladder, which asks, does the evidence show that your symptoms are so severe that you're unable to perform any of the jobs you've had in the last 15 years? Now be careful. That does not mean could you get that job. That company may have closed or may have moved to South Korea or to Mexico. It doesn't matter. It's whether you could function at that kind of job that you've done in the last 15 years. If we cannot prove that, if the Social Security is able to make a finding that your RFC, residual functional capacity, allows you to do any of the kinds of jobs you've done in the last 15 years, we lose at step 4. If we can prove you cannot, what do we know? We know from step 1 you're not working. We know from step 2 you have a severe impairment. We know it's not so bad it meets or equals the listings, but it is bad enough to preclude your old work. Now we go to step 5 on the ladder, which asks, considering your age, education, work skills, and most importantly, your RFC, are there other kinds of full-time jobs available in the national economy that you can perform? And this is when we fight over that ticket taker and coin changer and telephone salesman type jobs. If we can prove you cannot do those, we win. If we cannot, we lose. Every case at every level goes through exactly that analysis. The only cases that are approved are either compassion allowance or step 3 equal the listings, or step 5, we can prove such a diminished residual functional capacity that there's no work that that person could do on a full-time basis. All right, let's get more into lupus. Section 14.02 of the listings, 2 different ways to prove disability. This is a relatively recent update in the last couple of years, consistent with Social Security's pattern of making the listings more challenging. 2 ways to meet the listings. Number 1, prove involvement of 2 or more organs or body systems, heart, lungs, musculoskeletal functioning, with at least 1 moderately severe. That means not quite severely, but seriously. And along with evidence of 2 constitutional symptoms or signs, such as severe fatigue, fever, malaise, or involuntary weight loss. We're going to talk about proof of this in just a moment. Alternatively, the other way to meet the listing is repeated signs of lupus with at least 2 constitutional symptoms, same as up above, and at least 1 documented or proven marked or seriously limited activities of daily living, limitations in maintaining social functioning, or limitations in concentration, persistence, or pace. These are the only 2 ways to meet step 3 of the ladder, and that is meeting or equaling the listings of impairments. So every judge and every adjudicator in every lupus claim is going to start with these questions and look to see, is this met? If not, then they're going to develop their RFC, residual functional capacity, and continue on with the analysis. That brings us to step 5, which is, can we prove that the RFC is so diminished that you could not function at some of those other jobs? And the key here is proving the inability to work 8 hours a day, 5 days a week. It's called sustaining activity. A lot of people can be doing things for an hour or for half an hour or for half a day, and then they're wiped out for 2 days after that. If we can prove that, that's inability to function 8 hours a day, 5 days a week, and that would show such a diminished residual functional capacity that you'd be unable to work at any kind of a job. That ties into the most important slide in the whole talk, and that's this one. So I've talked a little bit about how challenging this program is, and that we've had over 50 clients die, and Social Security said they didn't even meet the listings, more or less getting into what their RFC was. But it's important to remember that we do win cases, and it's critical that we win cases. And it's important that we win cases for 2 reasons, to be really blunt and with all of you. The first one, and I'm only going to talk about my law firm, but it's pretty true, I'm comfortable saying, for any reputable, experienced Social Security practice, we turn away about 70% of the people that contact us because they're either not treating, or we don't think they're really disabled, or their questions aren't really related to Social Security, whatever the reasons are. But when we take a case, we really believe in that case. And if we believe in that case, we really believe that person should get the benefits, and we believe it's important that they win, and we work really hard to achieve that. The second reason why it's important that cases be approved is it's the only way we get paid. Nobody gives us money up front. Nobody pays us hourly. Nobody gets an hourly bill from us. The only way we get paid a fee is by winning. So it's really critical that we get cases approved. Our clients need it, and my staff salaries demand it. 3 rules to getting your case approved. And this is really the most critical thing we're going to talk about today. Rule number 1, you must be going to the doctor. You must be going to the doctor. You must be going to the doctor. I cannot say it enough. These are medical cases based upon medical evidence. I tell every new client, and so does Paulina, who's the only other person in my office I trust with seeing new clients. What you say, oh, Judge, I'm so weak, I'm so tired, I'm so dizzy, I can't function, is not evidence, because you want the money. As far as Social Security is concerned, you would testify under oath that I still had that full head of curly brown hair that I wish I had, but is long, long gone, as the barber points out every time. You would testify I still had those curls if that would get you $1,000 a month. What your spouse, child, next door neighbor, best friend, or priest says, oh my gosh, I feel so bad for her, she's suffering, that's not evidence because they like you. The only thing that's evidence in a disability case are the clinical charts of the treating specialists. Reports are nice, but reports are not the core evidence. The charts are the core evidence. It's an analogy I dislike because I've never shot a gun in my life, as you learn more about me. But people like to think of their lawyer as their gunslinger going out to fight for them. I don't shoot bullets. I wouldn't know how. Well, I like John Wayne movies, so maybe I could figure out a rifle. But much short of that, I have no idea how to shoot bullets. I shoot MRIs. I shoot blood tests. I shoot rheumatologist notes. I shoot Beck depression inventories. Those are my bullets. If you're not seeing the doctor, I have no evidence. If I have no evidence, there is no case. So rule number one, you must be going to the doctor. I can't say it enough. Rule number two, there's a right way and a wrong way to go to the doctor. And I'll talk about myself again. Very lucky, my brothers and I, we had wonderful parents who've been gone for a long time. I told you my old man was a roofer. Learned a lot from him, miss him every day. One of the things about my dad, he was a tough guy, but he was also the klutz. Remember I said I'd trip over my shoelace? Well, he would be on the roof and he'd be using the hatchet and he'd be banging on the roof and he'd invariably hit his arm and put a gash in it, but he wouldn't stop the job. The job had to get done. He'd spit on it, he'd put some hot tar on it, and he'd finish the job, and he never complained. My dad never complained a day in his life. He took care of his business and his responsibilities, took care of his wife, and raised his boys. The other thing about my dad is he was a big flirt. He flirted all the time, and I learned from him. My first wife, not so cool about it. My current wife, she gets me. It's a little better, but I flirt a lot. Now let's pretend that I'm seeing a psychiatrist, and a young, pretty psychiatrist. So today's my day to go see doctor, and I'm going to just pick a name, Dr. Jane. And I put on my shirt because today's the day that I'm not going to go in a t-shirt, and I'm going to pat down what's left to be patted down, and I'm going to trim what can be trimmed. And I walk into Dr. Jane's office, and I'm not a whiner or a complainer, and she's kind of pretty, and she says, Jeff, how are you today? And I say, I'm okay, Dr. Jane, how are you? And I just lost my disability case. Because what does she put in her chart? Well-groomed, nice man, says he's okay. Next month I go in. Now the shirt's a little wrinkled and the eyes are red, and I have this thing they call a flat affect, meaning I look sad. And she says, Jeff, maybe we need to adjust your medications. Tell me about your new symptoms. Oh, Doc, there's no new symptoms. I don't want to adjust my medications. I don't know how many of you have dealt with mental illness, either yourselves or with your family, but you know the last thing somebody with mental illness wants is to adjust their medications. Oh, no, Doc, there's no new symptoms. It was just a bad week. The dog pooped on the carpeting and the kid got a D on his report card. Really, there's no new symptoms. And Dr. Jane puts in the notes, Jeff says no new symptoms. Next month I come in and now I'm terrible. And I'm a wreck and my clothes are all dirty and I look bad and I'm kind of not answering her questions. And she says, Jeff, are you sure things are stable? Maybe we need to talk about that day hospitalization program over at Evanston Hospital. And what do I hear? Hospital. Done Chicago Behavioral, done Good Samaritan, done Linden Oaks. I don't like mental hospitals. No way. No. It's just been a bad couple of days and I didn't have a chance to clean up. And it was a fight I had with the policeman and it wasn't my fault. It was his fault or it was the fault of the other guy. You know how it goes. Really, I'm stable. What does she put in her chart? Jeff says he's stable. Those charts get read by a number of people internal to Social Security when they're deciding these cases. And what do they read? Stable, no new symptoms. Okay, case denied. Okay. I've lost cases because my clients don't tell the truth to Social Security. In a lupus case, it's particularly important because things like fatigue, which is a major symptom of lupus, cannot be proven. I can't prove fatigue, nor can I measure it. Do you have 3 degrees of fatigue or 6 degrees of pain? Do you have 2 degrees of joint pain or 5 degrees of joint pain? I can't prove it if you're not talking about it. What I tell all new clients is when you walk into Dr. Jane's office, you talk about the guy that you see in the mirror and pretend like you're following his life around. and you talk about his limitations and his frustrations. Number one, you'll get better medical care because that'll be in the charts and the doctors will be hearing it. And number two, when it gets into the charts, then it becomes evidence. Last thing, last rule, Social Security wants specialists. If depression is a part of your problem, and it is for most people that are chronically totally disabled, you need to be getting mental health help from a psychiatrist and a counselor or a good PhD psychologist. If your problem is lupus and you're treating with the family doctor, that's not going to cut it. If it's lupus, it's a rheumatologist. If it's a bad back, it's the orthopedic or the neurologist or the pain specialist. If it's fibromyalgia, it's the rheumatologist. Social Security wants specialists. There's very little room in this program for the family practice doctor. Their notes are useful, but they're not going to be determinative. Social Security wants specialists. Now, let me just check here. We're running a little low on time. These are the different steps once you determine that you have an application that should be pursued. The first level is called the initial application level. We actually, in our office, file the initial application for most of our clients now. We have one person whose only job is to do those applications. In Illinois, about 35% of the cases are approved at the first level, 65% are denied. The ones that get approved are the obvious cases like the double amputees and the heart transplants and the liver transplants. Lupus cases, unless there's really a lot of hospitalizations and really severe documentation, don't often get paid at the first level. Also, many of our lupus clients are under 50, which is considered a younger individual, and that's even a harder test. If we lose, we appeal, we go to reconsideration. In Illinois, only 10% of the cases get approved at reconsideration, 90% get denied. If we lose, we appeal once more, and this is when we reach the most important step in the process, and that's the hearing before the administrative law judge. And this is the most important step because it's the only time you get to go, well, we used to say face to face, now you get to go phone to phone with the decision maker. Everything up until the hearing is done by phone and mail. Actually, it's done by mail and records reviewed by obscure, unknown, unseen people down in Springfield. The only time you get to see and talk to the actual decision maker is when you're in front of the administrative law judge. Approval rates at the ALJ level have gone down dramatically over the last 10 years because of a lot of changes the prior leadership in Congress made to the system, but it's still the most effective step in the whole process. If we can't win in the administrative law judge level, we can appeal to the appeals council. You do not see them or talk to them. Their decision is based solely on what's done at the administrative law judge hearing. If we lose there, we can sue the commissioner in United States District Court and even appeal to the Seventh Circuit if we believe that's warranted. Again, you do not get a new trial or to testify. Everything is based on what happened at step 3, that administrative law judge hearing. That's the crux. We like to get hired as early in the process as possible so that we can have exactly this discussion with every new client, so that by the time we get to that administrative law judge hearing, we have the strongest possible record for that hearing and for any subsequent appeals if they're necessary. The rest of this presentation talks about what happens if you're on the program already. The only thing I'm going to spend time on now is continuing disability reviews. And what happens is we represent people and we yell at them, treat, treat, treat. We win their case, they stop treating. They stop because the doctor leaves, they get tired, nothing's changing. But then Social Security is going to do a continuing disability review, and everybody is going to be reviewed. You just never know when. No matter what they tell you, you never know when. The test is there medical improvement sufficient to allow you to return to work? They start with your doctors, but then you say, well, I haven't seen the doctor in a year. And a big smile comes to the adjudicator's face and he says, don't worry, honey, I'll send you to one of ours. And you'll go to a consultative examination where you'll get on the table, off the table, walk heel to toe, hold, count numbers backwards from 100. and you're going to found to have medical improvement, you're going to be terminated. So if you're on benefits, you're getting SSDI or SSI, what is the rule? You must be going to the doctor and continuing to communicate about your symptoms and problems. If you want to learn more about going back to work, you can contact us and we will send those to you, and these rules are pretty self-explanatory in the handout. I am going to take this page out because this is the NAMI DuPage page, which is not supposed to be in there. I'm the chairperson of NAMI DuPage right now, and I do some work with them. But there is a page I wrote that didn't make it into this that deals with the Lupus Foundation or Lupus Society of Illinois. And thanks, Mary, for all of the work. And when I send this out, it'll have the correct page in there. Our website is rkblegal.com. We're very proud of our website. There's a lot of information there. If there's things that you don't see there, please let me know and I will add it. Please like our law firm on Facebook and Twitter and follow us. We put a lot of information out there. I'm really proud of one of our associate attorneys, Spilios Bakayanis, who just got named vice chair and actually next year will become the chairperson of the Chicago Bar Association Social Security Committee. And we have a young attorney in Knoxville, Tennessee, Emma Drozdowski-Webb, who just was named as the chairperson of the Tennessee section on disability law for lawyers, Social Security lawyers in Tennessee. So I'm very proud of my staff when they have those kind of achievements. There's the page for the Lupus Society. Please support their work. It's critical. You must be involved. Their ability to reach into the community to provide information, support, and to lobby is only possible because of the support it gets from the community and from people like you. And thanks to Mary and her team for doing all this work today. There is my information, including my email, jeff@rkblegal.com. Mary, that covers everything that I wanted to cover. Are there questions that you've gotten in writing, or are there other questions that people have?
I have not gotten questions in writing yet, but I do want to thank you for you did an amazing job with a lot of information in a short amount of time. So I really appreciate it. It's now, we have a few more minutes left. If anyone has a question, if you want to chat it over to me using the chat function, or if you want to unmute yourself and ask the question, then that would be great. I liked your examples a lot, Jeff. I think you are very self-deprecating. But I guess, does somebody have a question?
I do. It's Madi.
Hi, Madi.
Hi. I have a question. Do you have a lot of cases where you have to fight in the administrator law portion?
I would say 90% of our cases end up in front of the administrative law judge.
Okay. That's where my case is at now.
We win cases every month at initial. We win some cases every month at reconsideration, but statistically, it's not many. If somebody calls us with a compassionate allowance case, that's so obvious, we don't even take that case. We tell them how to do it on their own so they don't have to pay a fee. So we win some cases early on, but we assume with every new case we take, the worst, that is, we assume we're going to end up in front of a judge, and we are always preparing for that.
Okay. You gave a lot of great information. I'm sorry that I came in late, but what I heard, it was amazing information.
Well, this is going to be on the Lupus Society webpage, and we'll probably put the link to that on ours and also probably on our Facebook page. So there's ways to listen to this again later if you want to hear my dulcet tones all over again.
Yeah, for sure. For sure. I want to hear the beginning part. Because I was, when I'm in court with my attorney, she kept on focusing on fatigue and I wasn't sure. And then I didn't know why. And then when you were talking about, that's one of the things I was like, that's why she was. So it's good. So now I know she's doing what she's supposed to be doing. I know what she's doing good.
That was important. Now, the key, though, is not to talk about fatigue at the hearing. The key to a good Social Security practice is to talk about fatigue at the very first meeting that you have with the client, so that the client understands why that's important and understands how every week and every month they have to be talking about that to their doctors. We actually give clients a calendar to keep on their nightstand to document all the symptoms they had during that day, to be a memory prompt when they go to the doctor. So we make sure that fatigue is very consistently noted, and weakness and numbness is very consistently documented, visit after visit after visit, over this longitudinal period of time, and that's how you prove those symptoms.
Man, you go, boy. Okay, thank you.
Thank you.
You know, somebody did chat over a question. I'll go ahead and read it. She said, I have lupus and its cousins and was told I did not need to have a physical anymore. I was confused. She also says, I have a question. The Social Security told me that they did not need any more information. If this person wants to unmute and elaborate on their question, that would be great.
Saying that they do not need any more information means that the state agency doctor probably already issued a recommendation.
Okay, my name is Barra. I come out of South Carolina, and I do have lupus and fibromyalgia and a couple of other things. And I have been keeping my doctor appointments. So when I talked to my person that they set me up to make the determination on my case, at first she was telling me that I need to have a psych evaluation and go see a physician, one of their physicians. Then 2 weeks later, which was this one day this week, she said, we don't need any more information from you, Miss McGee. So it kind of confused me.
Yeah, it means the state agency doctor already made the decision or the recommendation. It's also a big issue now with COVID because you can't have face-to-face examinations with Social Security's doctors very easily. And in fact, there had been a total ban on them for several months. Now some of the mental health they're doing by television, by telephone.
Yeah, they've been doing the telehealth here in Texas, a lot of that. And I asked her about that. She told me I don't need to see anybody else, but continue to see my doctors and continue to let them know if I have any more new appointments.
Well, what I'm going to hope for is that one of these days, pretty soon, you're going to open your bank account and find a whole bunch of money in there. We're going to shouts of yippee and hooray all the way up here in Chicago.
All right, I got your information. I'll just keep you posted then.
Very good. That would be great.
Thank you.
All right, so we'll take one more question. If no one else has one, I do. Okay, so this will be the last question. When you were talking about the caregivers, the people who like are raising the kids and they're and then they get hurt, is there any suggestions you would have for people in that situation, like the stay-at-home moms or dads, to protect themselves from that?
Yeah, keep working even a part-time job where you're still paying your FICA taxes and paying into the system.
Yeah,
I mean,
really, there's no other. There's no other.
No, there's going to never, unless we, and I don't want to talk politics, but
Sure.
I do. Unless we get a really strong Democratic majority in both the House and the Senate, along with the Democratic president, and even then, I don't know if it would happen. There's just not going to be recognition of stay-at-home parents being work. There have been bills proposed where stay-at-home parents would be offered the opportunity to pay into the FICA system and keep their quarters of coverage alive, which would be a wonderful thing. It would be costly to families, but it would protect them with these benefits, and it would protect their future retirement benefits, and it would be good for the trust funds. But who knows if that's ever going to really happen. So I can't really see in the near future there being much protection for stay-at-home parents.
Okay. All right. All right, wonderful. Well, Jeff, thank you again so much. It's always a pleasure, and you're always such a wonderful and dynamic presenter. I really appreciate it. As we've mentioned, this is being recorded, and it should be up on our website tomorrow. We'll send out an email, and we'll post it to Facebook. And we'll include the PowerPoint as well as a handout. I did want to remind everyone that we have a virtual walk. We had to cancel due to COVID the in-person walks, which is our major fundraiser for the year. And instead, we're doing virtual walks for the entire month of August. We're going to have fun activities and prizes and contests, and we would love to have you join. You can go to our website, www.lupusil.org, for more, or go ahead and shoot me an email. And with that, I will say thank you one more time to Jeff Rabin, and thank you one more time for participating in this evening's webinar. And I look forward to talking to you soon, or seeing you at the next one. Have a good night, everybody.
Thank you, everybody.
Good night, Mary.
Good night.
Thank you.
Thank you.